Good morning. It's a pleasure to welcome you here today in New York's never-ending winter. Glad to see you could get up so early and brave your way here. I'm very excited about today's conference, but first I want to give a few thanks. I want to thank Susan Petrone, the Assistant Director of the Center on National Security here at Fordham, for her painstaking work putting this conference together with me. You can imagine the CLE credit part of this, which I know many of you are here for, is God's work. So we've done that as well as everything else. Today we are looking at 21st century warfare, law, the enemy, and the battlefield. What I really want to begin by saying is that for the work of the center and for the other national security centers at law schools, basically this is what we've been looking at for 12 years. We've been looking at the legal paradigms, the legal authorizations, and the space between law and war. And so I thought it was time to have the conversation that probably we should have been having all along. Is what is the future of warfare for the United States? Where is the law involved? Where is it not involved? Who is the enemy? Who is the enemy going to be 5 years from now? Who is the enemy going to be 10 years from now? Where does the battlefield begin and end? You'll notice that there's a cyber panel tucked into the panel about how we generally think about war. It's a clue about where I think we're all going and where we'll be a year from now when we have our next conference. One thing to point out today at the outset is that lawyers have been unusually involved in the war on terror period. And if it was the case with the Bush administration, it's more so the case with the Obama administration. Lawyers are the spokespersons. Lawyers are behind the scenes and in front of the cameras. Obama has deployed his lawyers to explain to the nation what he's doing, why he's doing it, what his administration is thinking, and to try to make interface between the public and administration policy, which means basically that lawyers have been inseparable from the questions of policy, and particularly about war and how we're conducting this war under the present administration. There's really nobody better to speak about the issues to which this conference is devoted than Jeh Johnson, who recently left the Department of Defense as General Counsel. But before that, he's had other public service jobs. He was, as many of you know, a prosecutor here in the Southern District of New York for a couple of years. He was also General Counsel for President Clinton for the Air Force. There are many things you can say about Jeh Johnson, but from what I've seen and read and heard, here are the things I think are important to say. This is a man who understands the swell of history. This is a man who accepts the challenge of the responsibility of the fact that one individual, one man, one person of conscience, one woman, can make a difference. This is a person who believes that politicians and policymakers can leave a mark, whether it's a mark for good or a mark for ill. This is why we invited him here today. He reminds me of something that then Attorney General Robert Kennedy said here at Fordham when he dedicated this building to the law school at Lincoln Center. He said, quoting Justice Jackson, "The greatest attribute of a lawyer is courage." Jeh Johnson's thoughts on warfare are of a particular interest today. We know something about what he thinks, but not a lot. But here's what we do know, and I'm quoting from the speech he gave at the Oxford Union several months ago. War, he told the group assembled there, must be regarded as a finite, extraordinary, and unnatural state of affairs. War violates the natural order of things, in which children bury their parents, in which children bury their parents. In war, parents bury their children. He went on to say, we must not accept the current conflict and all that it entails as the new normal. Peace must be regarded as the norm toward which the human race continually strives. Today, we have gathered to think not just about the perpetuation of the current war against Al-Qaeda and associate forces, but about war, Is it desirable? Is it important? Is it possible to keep it from spreading? Do we want to keep it from spreading? What is the role of the law in thinking about warfare? And what is the role of the law in mitigating the run to war and conflict? Is there a point in a war without an armistice where the law can replace the military or at least mitigate it? Several of the panelists today have been involved in the past 24 hours in an intense debate that I invite you to read either in today's morning brief or on the Lawfare site about the authorization for the use of military force, which I think is something we're going to spend a lot of time discussing today. It authorized the force we have used, the United States has used after 9/11. Is it exhausting? Will it carry us through the next year? Will it carry us through the next decade? Or do we need more? These are the questions that confront the nation, and as before, lawyers, experts on the law, and others who are interested in the intersection between law and warfare need to confront these earlier rather than later. These are among the questions we'll ask today. I am delighted that you've come to join us. Without further ado, I give you Jeh Johnson.
Thank you very much, Karen. Can everyone hear me, especially in the back? I see heads nodding. Okay. Before I begin, I can't help but recall every time I teach at a CLE, I remember when I was general counsel of the Department of the Air Force about 12 and a half years ago, I was giving a talk, CLE, at the U.S. Embassy in London to our JAGs stationed all around Europe. And it was in an auditorium about this size, and I can't remember what I was talking about, litigation, civil litigation or something. And there, way in the back, was the ambassador, the U.S. ambassador to the United Kingdom in shirt sleeves, listening to my speech. And I finally could not resist the temptation any longer, and I asked him, Mr. Ambassador, what brings you here? And he said, South Carolina CLE, I need my CLE. Everybody needs their CLE. Thank you all for your interest in national security. I recall when I went to law school 30 plus years ago, these types of subjects were discussed in rather sleepy international law courses. I find it fascinating that there are whole courses and conferences devoted to what I used to do in my job daily. Anyway, thank you again for this invitation. Today I want to join the current public debate about a, quote, national security court, end quote, for the prior approval of lethal counterterrorism operations, or as some have put it, a, quote, drone court, end quote, end quote. Many have come down forcefully on one side or the other on this idea. My goal here is to set out what I believe are the pros and cons, based on my prior personal experience as the senior legal officer of the Department of Defense, as a former federal prosecutor, and as a career litigator. As a preliminary matter, I can't help but reflect for a moment on how we got to where we are. Most people, I think, do not have a quarrel with the bottom line conclusions and results. Most legal commentators would agree with the general proposition that a U.S. citizen who is a senior leader of Al-Qaeda and a terrorist, personally and actively involved in plotting from an overseas remote location to kill innocent American men, women, and children, and who cannot feasibly be captured or arrested, is an appropriate target for lethal force by the U.S. government. And most informed observers would agree, I think, that as a result of our government's counterterrorism efforts, spanning both the Bush and Obama administrations, and which have included targeted lethal force against known individuals, the U.S. homeland is safer today from a terrorist attack launched by Al-Qaeda from overseas. Some would say, if it's not broke, don't fix it. The problem, however, is that the American public is suspicious of executive power shrouded in secrecy. In the absence of an official picture of what our government is doing and by what authority, many in the public fill the void by envisioning the worst. They see dark images of civilian and military national security personnel in the basement of the White House, acting, as Senator Angus King put it, as, quote, prosecutor, judge, jury, and executioner, end quote, going down a list of Americans, deciding for themselves who shall live and who shall die, pursuant to a process and by standards no one understands. Our government, in speeches given by the Attorney General, John Brennan, Harold Coe, and myself, makes official disclosures of large amounts of information about its efforts and the legal basis for those efforts. But it is never enough because the public doesn't know what it doesn't know, but knows there are things their government is still withholding from them. The revelation 11 days ago that the executive branch does not claim the authority to kill an American non-combatant, something that was not, is not, and should never be an issue, is big news and trumpeted as a major victory for congressional oversight. A senator who filibusters the government's secrecy is compared in iconic terms to Jimmy Stewart. At the same time, through continual unauthorized leaks of sensitive information, our government looks to the American public as undisciplined and hypocritical. One federal court has characterized the government's position in FOIA litigation as Alice in Wonderland, while another this past Friday referred to it as, quote, neither logical nor plausible, end quote. An anonymous, unclassified white paper leaked to NBC News prompts more questions than it answers. Our government finds itself in a lose-lose proposition. It fails to officially confirm many of its counterterrorism successes and fails to officially confirm, deny, or clarify unsubstantiated reports of civilian casualties. Our government's efforts for the safety of the people risk an erosion of support by the people. It is in this atmosphere that the idea of a national security court as a solution to the problem, an idea that for a long time existed only on the margins of the debate about U.S. counterterrorism policy, but is now entertained by more mainstream thinkers such as Senator Dianne Feinstein, and a man I respect gratefully, my former client, Robert Gates, has gained momentum. To be sure, a national security court composed of a bipartisan group of federal judges with life tenure to approve targeted lethal force would bring some added levels of credibility, independence, and rigor to the process, and those are worthy goals. In the eyes of the American public, judges are, for the most part, respected for their independence. In the eyes of the international community, a practice that is becoming increasingly controversial would be placed on a more credible footing. A national security court would also help answer the question many are asking: what do we say to other nations who acquire this capability? A group of judges to approve targeted lethal force would set a standard and an example. Further, as so-called, quote, targeted killings, end quote, become more controversial with time, I believe there are some decision makers within the executive branch who actually wouldn't mind the added comfort of judicial imprimatur on their decisions. But we must be realistic about the degree of added credibility such a court can provide. Its proceedings would necessarily be ex parte and in secret, and like a FISA court, I suspect almost all of the government's applications would be granted because, like a FISA application, the government would be sure to present a compelling case. So at the same time, the New York Times editorial page promotes a FISA-like court for targeted lethal force. It derides the FISA court as a rubber stamp because it almost never rejects an application. How long before a, quote, drone court, end quote, operating in secret is criticized in the same way? Meanwhile, what about the views of the judiciary itself? I know a number of federal judges who would accept this unpleasant job, if asked, out of a sense of duty. But many, I suspect, want the judiciary to have nothing to do with this. Former judges Mukasey and Robertson have publicly articulated this view in emphatic terms. I can hear many in the judicial branch saying that courts exist to resolve cases and controversies between parties, not to issue death warrants based on classified ex parte submissions. Judges don't like arm's-length ex parte submissions because they know they are not getting two sides of the story. I'm sure they would like them even less if the decision they must make is final and irreversible. But in a more cynical way, I can imagine many federal judges thinking, quote, we don't exist to provide top cover to the executive branch for difficult decisions. Foist this responsibility on us and you diminish both our branches of government. Next, the advisability of a national security court depends in very large part on the scope of what it is the court will review and approve. I suspect the constitutionality of such a court depends on that as well. Here are three permutations, though there are more. First, a court to review and approve all targeted lethal force by the U.S. government away from any so-called hot battlefield against a terrorist, including in the course of a congressionally authorized armed conflict conducted by the U.S. military. Second, a court to review and approve targeted lethal force by the U.S. government away from the hot battlefield, but only against a terrorist who is also a U.S. citizen, again including in the course of a congressionally authorized armed conflict conducted by the U.S. military. Three, a court to review and approve targeted lethal force by the U.S. government away from the hot battlefield against a terrorist who is a U.S. citizen, but only in instances not part of a congressionally authorized armed conflict conducted by the U.S. military. Logistically, if this court's proposed jurisdiction is limited to U.S. citizens, then applications should be very rare, hopefully not even one a year. It is also the case that, as a result of FISA and other things, Article 3 judges can receive highly sensitive classified information ex parte. In Washington, D.C., the infrastructure for doing this already exists. But of course, limiting the court's jurisdiction to U.S. citizens leads to the inevitable question from other nations. Why do our citizens deserve less from your government? On the other hand, if the proposal is to include all targeted lethal force off the hot battlefield, that is a different matter. In that event, in the current world environment, the judge will have supplanted the senior legal official of a national security agency from a large part of his or her job. To do that conscientiously and effectively, one judge or another on this court should consider getting an office in the Pentagon or other agency and plan on spending a lot of time there. Be continually available, ever vigilant, and have continual around-the-clock access to secure communications, counterterrorism personnel, and executive branch lawyers to hear presentations, receive intelligence, probe intelligence officers for weaknesses in the intelligence, and ask lots of questions. This is not something to be done on the papers, as they say in court. Next, if the court's jurisdiction is limited to U.S. citizens, there is the question of exactly what the court is to decide. If one accepts the criteria for targeting a U.S. citizen set forth in the Attorney General's speech a year ago, it has several parts. First, the target is a senior operational leader of Al-Qaeda or associated forces who is actively engaged in planning to kill Americans. Second, the individual poses an imminent threat to the United States. Third, capture is not feasible. And fourth, the operation would be conducted in a manner consistent with applicable law of war principles. Starting with the last of these criteria, this one is implicit in every military operation. This includes consideration of, for example, the type of weapon used and the elimination or minimization of collateral damage. Often, these matters are and should be left to the discretion of the military commander in direct control of the operation. along with the time, place, and manner of the operation. Even if the overall approval of the operation comes from the President or Secretary of Defense, this particular aspect of it is not something that we should normally seek to micromanage from Washington. Likewise, there is also not much to be gained by having a federal judge try to review these details in advance. Next, there are the questions of feasibility of capture and eminence. These really are up-to-the-minute, real-time assessments of the type I believe Judge Bates was referring to when he said that courts are, quote, institutionally ill-equipped to assess the nature of battlefield decisions, end quote. Indeed, I have seen feasibility of capture of a particular objective change several times in one night. Nor are these questions ones of a legal nature, by the way. Judges are accustomed to making legal determinations based on a defined, settled set of facts, a picture that has already been painted, not a moving target, which is what we are literally talking about here. These are not one-time only judgments, and we want military and national security officials to continually assess and reassess these two questions up until the last minute before an operation. If these types of continual reassessments must be submitted to a member of the Article III branch of government for evaluation, I believe we compromise our government's ability to conduct these operations effectively. The cost will outweigh the benefits. In that event, I believe we will also discourage the type of continual reevaluation I'm referring to. That leaves the question of whether the objective is in fact a senior leader of Al-Qaeda plotting to kill Americans. Of those I have identified, this one is actually the simplest and most straightforward, but it is the only one that could plausibly be referred to a court, in my view. But it is not a question unique to U.S. citizens. Whether an objective is a combatant and part of the congressionally declared enemy is a question we should ask in every instance. Is it therefore really worth submitting to a court? Other considerations. Many like to draw distinctions between on and off a so-called hot battlefield. In my view, the distinction is becoming increasingly stale. On the one hot battlefield left since 2001, Afghanistan, the U.S. is winding down operations, while Al-Qaeda has migrated to Yemen and North Africa. Further, I can envision a lot of debate and uncertainty about what really constitutes a hot battlefield. Is it U.S. boots on the ground? If so, how many? Why should that be the test? What about Libya in 2011, for example? The distinction makes sense for developing policy, but I caution against the development of different legal regimes and standards on that basis. Next, a minor point. The phrase drone court is a catchy phrase that fits on a bumper sticker, but it is a conceptual misnomer. The activity we are talking about here is not limited to unmanned aerial vehicles. Targeted lethal force can be and is conducted from several other types of platforms, including manned aircraft. Then there are the constitutional issues. Again, this depends in large part on the scope of what we are considering. I agree with the analysis of Professors Gladdock and Epps on this subject. Article 2 of the Constitution states that the President shall be the Commander-in-Chief of the Armed Forces. This is his burden and responsibility. He may delegate it within his own chain of command, but he cannot assign part of it away to another branch of government, nor have it taken away by an act of Congress. The Article 3 problems are just as serious. The judiciary does not exist to issue advisory opinions or offer legal advice to the President. They exist to resolve live cases or controversies. Many refer to the FISA court by analogy to say that the FISA court, too, does not resolve cases or controversies between parties. It also authorizes surveillance based on classified ex parte submissions. But this judicial activity has its roots in the warrant requirement of the Fourth Amendment. What FISA judges do is an extension of what judges do every day ex parte in the domestic law enforcement context, when they issue search warrants. The idea of judicial authorization of lethal force against an enemy combatant, particularly during an armed conflict, has no similar roots in any activity typically performed by the judiciary. To the contrary, the idea is motivated by a desire to rein in the president's constitutional authority to engage in armed conflict and protect the nation, which is the very reason it has constitutional problems. Next, any requirement to submit certain objectives to a national security court must contain exceptions for the executive branch to act on its own in exigent circumstances. Again, is it therefore worth it? Also, beware of creating the wrong set of incentives for those who must conduct these operations. A lawful military objective may include an individual, whether his name or his citizenship are known. It may also include a location, like a terrorist training camp, or an object, like a truck filled with explosives. By creating a separate legal regime with additional requirements for an objective if his name or citizenship becomes known, what disincentives do we create for an operator to know for certain the identity of those likely to be present at a terrorist training camp or behind the wheel of a truck bomb? Or must the government refrain from an attack on what it knows to be an active and dangerous training camp if an al-Qaeda terrorist who might be a U.S. citizen wanders in? Here is my bottom line. Like others, I believe the idea of a national security court is worth serious consideration for the sake of our democratic process. I see certain advantages, but I also see a number of legal and practical problems. As I said before, the advisability of the idea also depends, in very large part, on the scope of what it is the court is to review. If I must be labeled one way or another, I guess I belong in the category of skeptic. What is my alternative prescription? I offer three things. First, continued efforts at transparency as an important government interest in and of itself, and not just to keep the press, Congress, and the courts off its back when its back is against the wall. That is easier said than done. Transparency is hard. The reality is that it is much easier to classify something than it is to declassify it. And there are huge bureaucratic biases against declassifying something once it is classified. Put 10 national security officials in a room to discuss declassifying a certain fact. They will all say, I'm for transparency in principle, but at least 7 will be concerned about second-order effects. Someone will say, this is really hard. We need to think about it some more. The meeting is adjourned, and the 10 officials go on to other more pressing matters. Last year, we declassified the basics of the U.S. military's counterterrorism activities in Yemen and Somalia, and disclosed what we were doing in a June 2012 War Powers report to Congress. It was a long and difficult, deliberate process to get there, but certain people in the White House persevered. We said publicly and officially what we were doing, and so far as I can tell, the world has not come to an end. Second, in my view, targeted lethal force is at its least controversial when it is on its strongest, most traditional legal foundation. The essential mission of the U.S. military is to capture or kill an enemy. Armies have been doing this for thousands of years. As part of a congressionally authorized armed conflict, the foundation is even stronger. Furthermore, the parameters of congressionally authorized armed conflict are transparent to the public from the words of the congressional authorization itself and the executive branch's interpretation of that authorization, which this administration has made public. Lethal force outside the parameters of congressionally authorized armed conflict by the military looks to the public to lack any boundaries and lends itself to the suspicion that it is an expedient substitute for criminal justice. Third, the president can and should institutionalize his own process internal to the executive branch to ensure the quality of the decision-making. In this regard, I will note the various public reports that the Obama administration is considering doing exactly that. This brings me to my final point. Let's not lose sight of the reality that in this country, we have for some time entrusted the President with awesome powers and responsibilities as Commander-in-Chief. He controls the nuclear arsenal, and he alone has the authority to use it. He alone has the constitutional authority, with certain limits, to deploy thousands of men and women in the U.S. military into hostilities on the other side of the world. Further, as we entrust the President to conduct war and authorize lethal force against an individual, that presidential-level decision brings with it a whole cadre of cabinet and sub-cabinet level national security advisors from across the defense, state, and justice departments and the intelligence community, who, in my experience, bring to the table different perspectives and engage in very lively, robust debate. I say only half-jokingly that in 2009, in the then-existing structure, one of the most progressive things the new president could do to promote credibility and ensure robust debate within the executive branch was add to the mix as State Department legal advisor a certain progressive human rights law professor from Yale, give him access to all our counterterrorism activities, and give him a voice and a seat at the table. And over the last 4 years of the administration, Harold Coe made me and others work a lot harder. Now, those who hear or read this will ask, what about the future? Coe is back at Yale. The answer is that the president we entrust with the ultimate responsibility is elected by the people and accountable to them. His legal and policy advisors are chosen just like a federal judge, appointed by the president and confirmed by the Senate. If the Senate is not satisfied that a nominee for a legal position in the national security element of our government will provide independent advice and follow the rule of law, it should exercise its prerogative to withhold its advice and consent. These days, the Senate delays the confirmation of a presidential nominee for a lot less. I am confident that the man we elected to be president for the next 4 years, Barack Obama, is sensitive to these issues. I also have a lot of faith in the new CIA director, John Brennan, who happens to be an alumnus of this university. Over the first 4 years of the Obama administration, I probably sat with him through somewhere between 50 and 100 situation room meetings. I believe I know his mind and his values, and in my opinion, John Brennan embodies what the president talks about when he says that aggressive counterterrorism policies, the rule of law, and American values are not trade-offs and can coexist. I finish with something I said a year ago at Yale Law School while I was still in office. As a student of history, I believe that those who govern today must ask ourselves how we will be judged 10, 20, or 50 years from now. Our applications of law must stand the test of time, because over the passage of time, what we find tolerable today may be condemned in the permanent pages of history tomorrow. Our national security and the people's faith in our government depends on this. Thank you very much.
We're going to have a few moments. Yes, we have to have a few moments, is what he means, of Q&A,
Sure.
and graciously. So raise your hand. I thought we might start with, if there are any panelists coming later in the day that have any questions they want to ask, this might be a good way to start off the day's conversation. Any of those who have a question? Otherwise, I'll just go to general questions. Okay. I see two. Are any of them panelists? Who's the other one? Okay, Jack.
David Cole has no questions, I can't believe it.
I know. He's saving them. He's thinking.
Hi. So if this court were to be only reviewing military strikes, as is the purview of the AUMF, what would you say to a hypothetical CIA armed drone program also having strikes approved by this court? And wouldn't that, in theory, make it illegitimate because it would be approving both military strikes under the purview of a military conflict, armed conflict, and also hypothetical CIA drone strikes by a civilian agency?
Well, I represented the U.S. military for 4 years. I can't and I won't comment on the counterterrorism activities of any other agency. In the permutations that I offered in my prepared remarks, I outlined 3, very carefully worded. One was all targeted lethal force, including as part of a congressionally authorized armed conflict by the U.S. military, all targeted lethal force against a U.S. citizen, including as part of a congressionally declared armed conflict by the U.S. military. And then my 3rd permutation was targeted lethal force against a U.S. citizen off the hot battlefield and not as part of a congressionally authorized armed conflict by the U.S. military. So one of the points I make, that I am making, is that targeted lethal force is at its least controversial and on its soundest legal footing when it is conducted by the U.S. military as part of a congressionally authorized armed conflict. I believe that's the case, and I've said that before. David?
I have 2 questions. The first deals with
what is judicially reviewable, and you suggested, well, the operational leader who has planned attacks and intends to engage in attacks, that's reviewable, but imminence is not reviewable. But as I understand imminence as redefined by this administration set forth in the white paper, it's not a up to the minute assessment of whether someone poses an immediate threat, but rather it's a categorical concept that certain persons who fit this category by definition pose an imminent threat to us. And so isn't that equally subject to judicial review as the first, even if feasibility is different? And the second question is, if we put aside courts and we're having an internal executive process, what about having a devil's advocate position? So you won't always have Harold Coe, right? But you could always have a defined institutional role of somebody whose job it is to defend life. And at least in terms of what's been leaked thus far, we're relying on Harold Coe, he's gone. We're hoping somebody else might be sensitive to those concerns, but there's nobody who has that institutional role. Wouldn't that make a more robust process?
I have a couple of responses. First, in my experience as the GC for the Department of Defense for 4 years, the application of what I think we would consider imminence is not necessarily what you would assume from reading that white paper. By the way, I'm not a big fan of white papers because in my private professional life, you don't give clients white papers because you don't know who authored it, who saw it, who signed off on it. So I'm not a big fan of white papers. And I have been in situations, I have seen situations where we were looking at a military objective, but we concluded that the threat was not imminent, and therefore not appropriate for the specific type of military force we've been discussing here. We would continue to monitor or pursue other means. So I'm not giving you a whole lot of detail here except to say that I'm not, in its application, in my experience, the standard does not necessarily line up with how one might read that white paper. If I had to write it, I'd probably write it a little different. Second, I like the idea of the devil's advocate, and something that I think could be made part of the process, could be institutionalized. Within the military, you have some special considerations. Suppose you make the devil's advocate an 06 colonel, and the objective goes up the chain, and all of a sudden the 06 colonel's got to be the devil's advocate in the face of some 3- and 4-star generals or admirals, and he's going to want to be sure that there's not going to be any blowback or retribution or anything for his being a good devil's advocate. But I actually believe that a devil's advocate is, or something of that nature, it would be a good practice. And as a career litigator, I'm accustomed to always making arguments, staking positions out, expecting that there's going to be somebody on the other side who's going to take issue with everything I've said, and that there's somebody in the middle that resolves the dispute. As a lawyer in the executive branch, as the senior lawyer for a government agency, you don't have that luxury most often. You're doing your own legal review. And I think it would be advantageous, and I know I've been in situations where I sit around the conference table and I say, well, would anyone like to be devil's advocate here among the 12 of you? And very often I assume the role of devil's advocate if I felt that no one else was. So I think it would be a good idea. Yes, sir. Matt.
Thank you. I guess my question is, what is the practical operational standards of proof before you authorize someone to be killed, American citizen, American resident or not? Is it, effectively proof beyond a reasonable doubt? How sure are you? And how sure do you have to be? And how sure do your people have to be before you kill somebody?
There is a standard that we apply in the Department of Defense. I'm not sure it's public, unfortunately. I caution that we, lawyers in particular, want to think about these things in litigation, law enforcement terms, because we are used to, experienced with dealing with evidence admissible in a court, hence terms like proof beyond a reasonable doubt, reasonable suspicion, preponderance of the evidence. And what you're dealing with in armed conflict and counterterrorism is intelligence very often, not evidence, intelligence. And I always bristled when in those contexts people would want to talk about evidence. It's not evidence. Evidence is something that a judge admits into a trial proceeding because it meets certain thresholds appropriate for a courtroom. What we're doing is assessing intelligence. And you want the intelligence to be reliable, you want it to be dependable, and you want to be pretty darn sure that you're acting on the appropriate level of intelligence before you make a decision. And because there are lots of things that in the intelligence realm one is allowed to consider that you don't consider in court, very often those judgments, in my opinion, in my experience, can be pretty reliable. Sometimes they can be sketchy, but sometimes they are very, very reliable.
It just seems to me if you want to increase transparency, and you want to increase the faith of the American people in decision making, this is one area that you ought to disclose. There's a standard. There's a standard that's being used.
I'm not disagreeing with you. I don't believe that there is a standard. I don't believe it's public. Yes, sir. Phil Carter.
Thanks, Jay. To some, the current authorization for the use of military force is sort of like an old pair of jeans. It's comfortable by now, but it's got a few pairs of holes in it. I was wondering if you could talk to the current debate over the AUMF and whether you thought that it needed to be revised, updated, expanded, or kept in place.
That is a very good question, and I know that there is a hot debate going on in lawfare among people in this room on that very issue. And I'm anxious to immerse myself in what's been written on the subject. I've only looked at it very quickly. I think the answer depends almost entirely on what are the existing threats out there right now. What are the threat streams? And at this point, three and a half months out of government, knowing how often threat streams can change, I don't feel equipped to make that judgment. I know it's publicly available, but I think it depends in very large part on what the threat streams are. And for the 4 years I was in office, I thought that we made the AUMF work. Our interpretations in the executive branch of the AUMF were sustained by the courts in habeas litigation, and the Congress last year or the year before last, in section 1021 of last year's NDAA, codified our interpretation in the detention context. That became the subject of litigation here in New York. But the Congress codified it, so all three branches essentially came to an appropriate interpretation of the AUMF, which I thought worked for the 4 years I was in office. Now, there's a point beyond which, if you want to get at various threat streams, various terrorist organizations, various affiliates, I've even seen talk about affiliates of affiliates, that the AUMF is just simply not going to work. And it was intended for a specific group that existed in 2001. And one of the things that I said at Oxford was that there's a point where that core group has been decimated so that the enemy, as we knew it in 2001, no longer exists. At that point, our national leaders, the President and the Congress, have a decision to make. How do you want to deal with the future threats? I think it would be unfair to simply ask the lawyers in the executive branch to just keep making this AUMF thing work. Just keep interpreting it so that we meet the existing threats and don't bother us in the Congress with this. So our national leaders have to make a decision based upon the existing threats, whether we want, as a government, as a country, a new congressional authorization to deal with existing threats, or whether we revert to reliance on more traditional means for our counterterrorism activities, law enforcement, intelligence community, and the military for imminent threats. And so that's a judgment that has to be made with all the best available, most recently available intelligence at hand. I don't know. I mean, the New York Times editorial page the other day, the editorial page editor of the New York Times happens to be a good friend of mine and a neighbor. We debate all the time about these things, and I'm just not sure how one can call for repeal of the AUMF without knowing what the current threats are out there. I appreciate that. So, yes, sir.
Imagine the written record test of the determinations made to authorize the targeting of an American citizen. Is that record preserved in one agency or several agencies? Will it be preserved, and when might it become available to the public? 25 years, 50 years? Is it some? Will it ever become available?
I didn't get the first part of your question. What is it? Something you're asking?
Will the written record of these determinations ever become available to the public?
Of interrogations. Oh. That's a good question. We're not shy about making FOIA requests, and if they don't get what they want in FOIA, they bring litigation. And it's at some point, I suppose, years from now, internal deliberations classified by our government could become available. And the government can always, for the sake of transparency, consider declassifying certain components of its internal decision-making about counterterrorism. I think that there are other ways that we can promote transparency, pursue transparency, without necessarily releasing any kind of written record of internal government deliberations.
How likely is it that it will be set in 20 years?
In 5 or 20 years from now,
5 or 20 years or ever? How likely is it?
how likely is that?
Set up a drilling for.
Well, as I said, I am a skeptic, and I think that as we speak, the world environment may also be shifting, such that we may, in the future, rely, as I mentioned at Oxford and here again today, on more traditional means of counterterrorism. It really is the case that armed conflict, targeted lethal force should be regarded as extraordinary in an extraordinary state of affairs to deal with an existing threat that our government came to grapple with over 12 years ago, so almost 12 years ago. So I think that there's a current debate that deserves a lot of attention, and people in Congress in Washington need to have this discussion. But as I tried to lay out this morning, I see some real practical and legal problems. So, okay. I'll take one more question. Yes, sir. Gentleman in the red tie. I'm sorry if I missed anyone who said their name.
Thanks to your remarks, Mr. Johnson. I wonder if you could say a bit about the feasibility of capture wing of the test. Is that purely an operating question? Is it fair to take political effects into account? And how do you create an incentive for agencies to develop a greater ability to capture in the future?
Well, thank you for asking that, because I failed to make a point that I wanted to make earlier, which is that when we talk about questions of eminence, feasibility of capture, those are not legal questions. Those are not necessarily legal questions, and lawyers, judges, don't necessarily have to be the ones to make those calls. Very often, a military officer, some civilian national security official is fully equipped to make a judgment about evidence based upon his or her assessment of the intelligence. And so what I've seen happen is lawyers tend to believe that only lawyers can answer these questions. And a point that I think needs to be emphasized is that lawyers set the outer boundaries for things. Lawyers set the lanes, the legal lanes in which military leaders, president, policymakers operate. So lawyers can come to a judgment, and I've seen this countless times. Lawyers come to a judgment that something or someone is a lawful military objective, but there are lots of policy reasons, lots of military reasons why that individual should not be acted upon, even though he's a lawful military objective. And so the point I'd like to make here is that lawyers set the lanes, the outer lanes, in which there are a lot of judgments that get made by non-lawyers about how to pursue armed conflict, how to pursue counterterrorism. And so there are plenty of people equipped to make judgments about eminence, feasibility to capture, not necessarily lawyers. We lawyers think we know it all, but we don't always have the best skill sets for making these decisions. So, okay, thank you all very much.